You feel the flash of red and blue in your rearview mirror, the sudden knot in your stomach. A routine traffic stop. For decades, the familiar script is played out. You have the right to remain silent, the right to refuse certain searches, the right to an attorney. These are the pillars of our liberty at the roadside. But what if those pillars are being quietly eroded, not by a dramatic Supreme Court ruling, but by a confluence of technology, legal precedent, and legislative shifts? What if by 2026, the constitutional landscape you drive through is fundamentally different? This is not speculation. It is a legal reality unfolding in courtrooms and police departments across the United States. The intersection of privacy, technology, and law enforcement is being radically redrawn, and your rights during a traffic stop are changing. This comprehensive analysis will detail 4 critical protections that are diminishing, explain the complex legal machinery behind these changes, and provide you with the actionable knowledge you need to navigate this new terrain. This is not about fear-mongering. It is about forensic education. The law is not static. It is a living entity, and in the realm of traffic stops, it is evolving in ways every citizen must understand to protect themselves. The erosion of the reasonable expectation of privacy in your vehicle's digital cortex. Historically, your car is in effect protected by the Fourth Amendment, but with a lower expectation of privacy than your home. The new frontier is your vehicle's digital data. Modern cars are not merely mechanical conveyances. They're rolling networks of computers called electronic control units, ECUs. By 2026, most vehicles on the road will have sophisticated telematics systems, event data recorders, EDRs, black boxes, and infotainment systems that constantly log and store data. The legal shift. The Supreme Court's precedent in Carpenter v. United States, 2018, established a high bar for accessing historical cell phone location data, requiring a warrant. However, the landscape for vehicle data is murkier. Lower courts are increasingly applying the third-party doctrine and the motor vehicle exception to the Fourth Amendment. Third-party doctrine. You voluntarily give data to your car's manufacturer or service provider, like connected navigation services. Some courts are ruling that this data is no longer purely yours, and if police obtain it from the company, sometimes with a subpoena, not a full warrant, it may be admissible. Motor vehicle exception. This long-standing exception allows police to search a vehicle without a warrant if they have probable cause to believe it contains evidence of a crime based on the vehicle's ready mobility and lower privacy expectation. Prosecutors are now successfully arguing that extracting data from a car's systems is a search of the vehicle itself, falling under this exception. If an officer smells marijuana or claims to and has probable cause, they may not just search a glove box. They may plug a device into your onboard diagnostics, OBD2, port or access your infotainment system to download call logs, text message metadata, location history, and even driving behavior, hard braking, rapid acceleration, to build a case against you. What you're losing. The clear, warrant-based protection for your digital footprint within your car. By 2026, the precedent may be solidified. The trove of personal data in your vehicle's computer may not require a separate, specific warrant to access following a lawful stop, drastically expanding the scope of a search. What you need to know. Understand that your car is a witness. Inquire if your vehicle has a built-in data collection and privacy policy. Know that refusing a voluntary search of your physical car may not prevent a digital data extraction if probable cause is established. The most effective countermeasure may be technical. Using a standalone GPS device instead of built-in NAV, frequently deleting paired phone data from the infotainment system, and understanding that factory reset options may exist for your car's computer systems. 2. The practical nullification of the right to remain silent through routine questioning and algorithmic analysis. You have the right to remain silent. Miranda is sacrosanct, but it only applies during custodial interrogation. A traffic stop is initially considered a temporary, investigative detention, not custodial. Officers have vast latitude to engage in routine questioning. The legal shift. The erosion here is subtle and procedural. Officers are trained in the ABC method. Always be conversing to bypass silence. Questions like, "Where are you headed tonight?" or "Do you know why I stopped you?" are not considered interrogation. They are rapport building or investigative. Your polite, nervous, or evasive answers create articulable facts that can quickly elevate reasonable suspicion to probable cause. More critically, emerging voice stress analysis, VSA, and linguistic analysis software are being piloted for in-car or post-stop use. While not universally admissible as direct evidence, these tools can provide officer insight or investigative lead justification. Your voice, captured on dash or body cam, could be analyzed in real time or later for signs of deception, feeding into an algorithm that tells the officer to dig deeper. What you're losing: the practical ability to exercise your right to silence without penalty. Remaining completely silent during a non-custodial stop can be perceived as suspicious, potentially prolonging the detention. The space for casual conversation that is actually a forensic investigation has widened. The sanctity of your unanalyzed voice and word choice is diminishing. What you need to know: you must be strategic. You can politely and calmly state, "Officer, I am choosing to exercise my right to remain silent on all questions beyond what is required for this stop. I will provide my license, registration, and proof of insurance." This is a clear, legally sound invocation. It may not prevent extended detention, but it creates an unambiguous record that you asserted your right. Be prepared for the stop to become less friendly, but remember, your goal is legal protection, not rapport. 3. The diminution of protection against prolonged stops through the dog alert and remote warrant expansion. In Rodriguez versus United States, 2015, the court ruled a traffic stop cannot be prolonged beyond the time needed to handle the mission of the stop, checking license, registration, writing a ticket, without reasonable suspicion of other crime. This was a victory for privacy, but legal workarounds have flourished. The legal shift. First, the K-9 unit alert. Courts routinely hold that the time it takes for a drug dog to arrive and sniff around the car does not constitute an unreasonable extension if done within the normal time frame of the stop. Police departments are streamlining this by having K-9 units staged or using pass-along scheduling to ensure a dog is nearly always minutes away. The dog's alert, now often from behavior allegedly detectable only to its handler, creates immediate probable cause for a full search. Second, and more transformative, is the explosion of remote warrants. With officers equipped with smartphones and tablets, they can now draft a warrant affidavit, have it reviewed by a prosecutor, and presented via video call to a judge on duty, all while you sit on the curb. This process, taking 15 to 30 minutes, is increasingly being ruled as not a prolongation, but part of a diligent investigation. The legal argument is that they are not waiting idly. They are actively pursuing a warrant based on the suspicion they already have. What you're losing: the Rodriguez protection against indefinite, exploratory holds. The mission of the stop is now elastic, encompassing the time to secure a digital warrant. The threshold for the reasonable suspicion needed to initiate this warrant process is being lowered, as the officer knows a judge is just a FaceTime call away to approve a deeper dive. What you need to know: if an officer tells you they're waiting for a K-9 or applying for a warrant, you must ask calmly and clearly, "Officer, am I free to leave? If not, I do not consent to any extension of this stop or any search." This formalizes your non-consent and objects to the prolonged detention. The answer will almost certainly be no, you are not free to leave, but you have now created a critical marker for your defense attorney. The battle will shift to whether the officer had valid, independent, reasonable suspicion before the original stop's mission was complete to justify the warrant request. 4. The weakening of the right to refuse consent searches through the psychology of opt-out, burden, and implied consent 2.0. The cardinal rule has always been, you can say no to a consent search. A no must be respected, though it may lead to other actions like a dog sniff. The pressure to consent, however, is becoming more sophisticated and legally embedded. The legal shift. This is a two-pronged attack. First, the psychology of the request. Officers are increasingly trained to use a presumptive, normalized script. Okay, sir, while I run your license, I'm going to have you step out, and I'm going to do a quick safety pat-down and check the car. Just standard procedure. This is not a question. It's a statement of action. The social and psychological burden on the driver to vocalize an objection, to opt out in front of an authority figure, is immense. Many courts view a driver's silent compliance as implied consent. Second, implied consent laws, traditionally for DUI breath/blood tests, are seeing conceptual spillover. Some jurisdictions are passing laws or advancing legal theories that by using public roads, you imply consent to advanced surveillance techniques used during stops. This could include automated license plate reader, LPR, historical checks, facial recognition scans via body cam, compared against databases in real time, or even passive cell phone signal interrogation. Your refusal to cooperate with these digital searches could be construed as a violation of the implied consent statute, leading to automatic license suspension or enhanced penalties, mirroring DUI refusals. What you're losing: the clear, uncoerced power of a simple no. The legal and social framework is shifting to make refusal feel more confrontational, more suspicious, and potentially more costly. Your mere presence on the road is being interpreted as consent to a new layer of digital inspection. What do you need to know? You must retrain your response. Hear any statement of action as a request. Your response must be polite, unambiguous, and verbalized. Officer, I do not consent to any searches of my person or my vehicle. I am invoking my Fourth Amendment rights. Say it clearly. It may be recorded on body cam. This removes all ambiguity about implied consent. Regarding digital scans, the law is nascent, but the same principle applies. I do not consent to any facial recognition scan or digital search of my devices. You're placing the legal onus back on the officer to justify their actions without your permission. Voiceover note. Pause, then deliver the following question with measured suspense. Given these converging trends, the digital data harvest, the analytical conversation, the streamlined warrants, and the pressured consent, one must ask, when every vehicle is a data terminal and every stop is a potential forensic audit, at what point does the traffic stop itself cease to be a minor infringement and become the central tool of a surveillance state? This is the question you must answer, not just for lawmakers, but for yourself the next time those lights flash behind you. Conclusion and call to action. The traffic stop of 2026 will be a more complex, data-rich, and legally fraught encounter. Your defenses are no longer just about knowing your rights, but understanding their new limitations and the sophisticated methods used to circumvent them. Passivity is perilous. Knowledge, precise language, and calm assertion are your new essential tools. This information is your first line of defense. The law will continue to evolve, and staying informed is not a one-time event. To navigate this changing landscape with confidence, you need ongoing, clear-eyed legal analysis. If you found this deep dive into the shifting sands of your constitutional rights valuable, you must ensure you don't miss the next critical update. Subscribe to the channel now. Hit the notification bell. In the coming months, we'll be breaking down exactly how to craft your roadside protocol, what to say, what not to say, and how the rulings of 2025 are setting the stage for the world you'll drive in next year. Your liberty deserves vigilance. Subscribe today.